Good morning, and may it please the court. Before I turn to this court's questions as well as the fallacies in petitioner's arguments, I want to remind the court about what the requests here are really about. They're not about the name or the address or any other identifying information. They're about a request for the total number of calls placed to the child abuse hotline from each of 3 publicly known child care facilities, Mount St. Vincent, Cleo Wallace, and the Tennyson Center. And what's really important, let's focus on the Tennyson Center. The Colorado Child Protection Ombudsman had previously released that in 2020, which is one of the 3 years that respondents had requested for, there were 113 calls placed from the Tennyson Center. At every opportunity, at the trial court, at the Court of Appeals, and here, counsel for petitioners has never made a connection between that 113 number and any identification of any child, any family, and any other informant or other person that might be involved. And that's because it can't be done. It's not a matter of hypotheticals. There are hypotheticals about tattoos, about a leather jacket, about an aunt talking about her nephew, or a high school basketball coach. Those are the details that reveal the identity of one of the victims, the families, or the informants. Knowing that there were 113 calls placed in 2020 doesn't give the media or anyone else any more information to identify anyone.
So I don't know that you said anything wrong, but let me just push back a little bit. I think opposing counsel would say that the legislature wants us to be worried about the potential confluence of information that may be something along the lines of the hypotheticals that you were just reminding us of, right? People have other information, so it's not that hard to piece together. Even if it didn't happen here, shouldn't we be protected against the possibility that it might happen in certain scenarios? We tend to be very circumspect when it comes to this kind of information.
Absolutely, Your Honor. And the interpretation that we've proposed and the Court of Appeals adopted does accommodate for that. It accommodates for it because unlike a residential address, which has publicly known information that someone can tie that address to a particular name, so that is a disclosure of a name and address when you disclose a residential address, the Tennyson Center, with 113 calls, doesn't disclose the address of anyone actually living there. At the time of this request, all of those children would have cycled through, in and out, and it cannot be pinpointed to any particular date, any particular child who is residing at that location. And our interpretation doesn't prevent the petitioners from being able to discern, using common sense, whether there is a risk. The answer here wasn't that we can't tell whether this might be identifying information. It was an absolute. And their interpretation, this plain language interpretation, while it's reasonable on its face, is unreasonable in the results it creates. It creates a result that is, first, contrary to the purpose of the statute, which is in 302, where the legislature expressly said, we want statistics, we want information disclosed. It expressly referenced the CORA in order for us to be able to determine whether those facilities are being properly managed.
Am I right that the request was for the number over the course of 3 years?
It is.
Okay.
And my point was that the ombudsman, had released the data for 1 year. So we know the number is going to be 113 or more for the Tennyson Center.
So why doesn't the aggregate data that they provided, or maybe more specifically that they offered to provide, enough to satisfy the public policy interests that you're articulating?
Because it doesn't allow the public to determine which facilities are actually failing in their mission.
Well, if you have 3 facilities and the data in the aggregate as to those 3 facilities is appalling, why isn't the point already made?
The point isn't about whether the DHS itself is failing. It's whether those facilities, specific facilities, are failing. We know that, for instance, the El Pueblo Boys and Girls Ranch had 243 calls to the child abuse hotline, and that resulted in the closure of that particular center. That kind of oversight is critical. Being able to jumble it together where now you don't know which child care facility is actually failing.
I suppose you could have 500 calls, 480 of which came from Tennyson, 10 of which came from Cleo Wallace and 10 of which came from the third one.
I won't argue against that, but that's a
And I
perfect...
don't know,
No,
hope
but
that's not the case. But
I would hope so. I would also hope so. But the issue here isn't about sensationalism. I mean, they reference media sensationalism. That's not what this case is about. This case, as I just mentioned it in the opening, is about the oversight of the functioning of these facilities that are supposed to keep victims safe. And when there's a child abuse call from those facilities, that suggests that they're perhaps not meeting their mission. And again, the requests here were not for a specific date. They were not asking for any specific or identifiable time period where you can say, well, fine, now it's a narrow category of individual because it's a week or it's a month. The request was for 3 years. And functionally, it's even broader in terms of the inability of anyone to identify a particular individual than the ombudsman's disclosure on multiple prior occasions.
To your knowledge, did they complain about the ombudsman disclosing the 113 complaints out of the Tennyson Center?
She was never prosecuted for that, no.
And how does the ombudsman get access to that? Does the ombudsman have access that your clients would not have?
I believe the ombudsman, according to Petitioner's Counsel, just obtained that statutorily. I could be wrong. I'm not aware of how the ombudsman obtains that information.
But as far as you know, they obtained it from DHS.
Correct.
And the DHS, given that 113 complaints is already public with respect to the Tennyson Center, did they respond to your request, at least in that limited fashion, to say, well, this is already public, so we can say, these 113 already, but we won't say anything else about the other ones?
No, they, in fact, cited 3071A as an absolute, unequivocal denial of the requests.
Mr. Belkin, let me give you a different scenario, because you're talking about 3 years, 3 different facilities. What if you are asking for, I just want the number of reports on this day from this facility?
I would argue at that point it would be clearly identifying.
Okay, so what rule would we write then?
The rule is already in the statute itself, and it's not something that you need to worry about because it already says any other, and the word other is clear here, other identifying information contained in the reports. That requires DHS to exercise its judgment, and in fact, to the extent that they are unsure of whether that information is disclosable, there is a process already in place under the CORA. 2472-204 subsection 6 provides that if in good faith and with reasonable diligence they're unable to determine whether this is something they should disclose, they can seek a court order to determine that. And that's precisely what the Children's Code provides, where a court can order the disclosure of the material.
I appreciate you viewing this simplistically, but the problem is we need to be able to define other identifying information when, because what you're saying is over 3 years, 3 different facilities not identifying, otherwise identifying information. One day, one facility is identifying information. So how do we define that then?
Well, I think the test is it's reveals or is likely to reveal or could reveal. All of those are fine. And that's where they have to exercise judgment, as every custodian has to, with respect to an open records request. I would concede that if you narrow enough the request to the point that it's now a very limited subset of potential individuals, that it would be potentially disclosing the name and address of those individuals. But
how would you know that on any particular day which certain individuals were there? I guess I'm following up on the question from Justice Boatwright, which I think is a good one. If the request is how many reports, just a number, you received on a particular day, what does that identify?
Well, Your Honor, that is a great question. If it's 30, it probably isn't identifying anyone. But if it's 1, I will concede that their parade of horribles that they listed, potentially there is somebody out there who knows that there was a call placed about a child abuse on that date and now can tie it to that particular location. But we don't need to worry about that because ultimately that type of analysis can be done, should be done by the custodian, and that's provided for in the statute itself. Because if their argument is that that can't be done, it's too difficult, then that catch-all phrase swallows the entire statute, because they can always claim that it's too difficult for us to determine, and the catch-all allows us to not disclose it, no matter what the information is. So there has to be some reasonable interpretation of that.
Mr. Belkin, let me feedback what I think you said the test is. I want to make sure I'm tracking with you. So your interpretation would be, we get down to a factual question here, whether the request in a particular instance reveals, could reveal, or is likely to reveal the identity of a child or the informant or whatever it may happen to be.
Correct, Your Honor.
And then the example you gave on the 1 day is that may be more likely to reveal, could reveal, et cetera. And it would depend on the facts. And your position is if DHS, maybe they can say this would identify a child. It was one report, fine. Or they may say, not sure, this is a closed case and they should go follow the procedure under CORA. That's just feeding back what I think I heard you say. Is that right?
Well, I think that there's a spectrum of responses there. The first response, if it's a number low enough, they simply deny the request, saying that it would likely lead to the identification of an informant or a child or a family. If it's a number that's somewhere between 1,000 and 1, and it's one where they have, through reasonable diligence and thought, cannot come up with the correct answer, they can deny it, certainly, and now that could be challenged in court, or they can choose the safety valve that's provided by CORA that allows them to seek judicial intervention and help. I mean, this case has been pending for 4 years.
But that, I have to tell you, that's my concern. I mean, you both agree on the test in this case. So what should give me, any kind of optimism that the test is going to work well? This is the test that both of you are saying applies, and here we are. You've been in litigation for how many years did you say? 4?
4 years.
You're now at the state Supreme Court, and it's the test that both of you say applies, and you see it very differently.
We don't, actually, because if that test applies using all the logic and reason this court has, there is no way that knowing 113 or more calls placed from the Tennyson Center is going to reveal the identity of any of the individuals protected by 307(1)A.
So I guess I'm curious whether, in fact, you do agree on the test. I didn't read the briefs that way with respect to my friend Justice Amore. I mean, it seems to me their position is anything at the address is subsumed the answer. It's identifying, period, hard stop, name, period, hard stop, identifying. You say not. You say the address is confidential if it would lead to identifying.
You're correct, Justice Gabriel. We agree on the test for identifying information.
Okay.
We don't agree that the statute is read the same way.
No,
we
right.
absolutely disagree about
But
that.
I'm talking about the test for identifying information. I worry about adopting that test because I think it's going to engender litigation. I just think they're going to look at it and go, yeah, that one would lead to identifying information, and your clients are going to say no, it wouldn't. I mean, that's why we're here.
And unless it's subject to clear error review because it's a factual issue. Is that what you're suggesting?
I think abuse of discretion would be the appropriate standard, but let me answer your question, Justice Samler. The catch-all phrase already places a burden on the custodian to make a call as to whether or not any other identifying information that's called for by a request. Let's presume it's not a request for the total number of calls. Let's presume it's not a request for the name or address, or implicitly could reveal the name and address. Let's just assume that it's some other detail. That any other identifying information contained in the report requires them to determine whether disclosing that information is likely to reveal the identity. It's already there. And 99% of the time, asking for the residential address of a particular call, it's going to be automatically identifying information. It doesn't matter if it falls within the name and address or into the catch-all phrase. It's automatic. We're talking about the very purpose of Section 302 and the balance that it strikes between the Open Records Act and allowing the public to supervise the functioning of government, and in particular here, the facilities that are supposed to be keeping these children safe, and the critical privacy interest. Now, we don't dispute...
Mr. Belkin?
Yeah.
Sorry. Go ahead and finish your thought. And then...
We don't dispute that the privacy interests of the children, the families, and the informants are paramount. What we dispute is that our clients' requests here called for disclosure or likely to disclose any of those.
So I mean, you have any number of really compelling public policy reasons, but the legislature, the General Assembly, in the first instance, gets to decide where to draw these lines. So at the end of the day, if this case turns on whether we think 1A is ambiguous, why don't you run us through the best argument you have about why this is?
Absolutely. While they're reading that name and address, actually should be name or address, is always identifying information by definition under the statute, that reading runs into several problems. First, the same reading has to apply to reports, but clearly reports are not entirely confidential and identifying. And so that last provision says any other, and I highlight other, identifying information contained in the reports. So that last provision is already modifying the first two aspects, the reports and the name and address. That's the first. And that's,
why? Why does it necessarily modify name and address? Why can't it be read that name and address automatically qualify as identifying information? They're examples of identifying information.
And that could be, Your Honor, but then that would run afoul of Peck's interpretation. Because frankly, if Ms. Peck had said, I have an email that shows there was another victim who had a call placed from the Tennyson Center about child abuse, that could subject her to the potential for criminal and civil sanctions. And not limiting it to purely identifying information would not be narrowly tailored. So, and I disagree with counsel. Peck did analyze 1A because Judge Jackson below determined that both 1A and Section 4, subsection 4, were both unconstitutional. And the 10th Circuit said, no, wait, 1A is naturally limiting. It only applies to identifying information, not everything that could be potentially in the report, but just identifying information. It didn't narrow it to the catch-all phrase. It narrowed the entire statute under the doctrine of constitutional avoidance.
That doesn't answer the question here. My point is name and address automatically qualify as identifying information. They are examples of identifying information. Name, identifying. Address, identifying. And other identifying information are precluded.
But that would cause the problem with somebody disclosing the fact that the Tennyson Center, if you read the request here to call for an address, assuming you get that far, that statement by Ms. Peck that there were an additional call made to the child abuse hotline from the Tennyson Center would automatically be a violation of 1C.
Well, interestingly, we're not actually bound by the 10th Circuit, just saying. Can I ask what your thoughts are about my view that the residential facility is not actually the address of the child, that the child's legal address is the home address, which is clearly identifying information? I realize that's not an argument that you made in your brief. You did argue with, I think it's encompassed within your arguments in that you say that the address of the facility, which we all know, is not identifying information of the child, of any particular child.
Your Honor, I'm not smart enough to know what the legal address is under the definitions of all of the statutes, but I think I can answer that question without conceding the point. And that is the name and address refers to the information contained in the report. And the name and address, in that instance, the address is the address from which the call was placed.
Okay.
So as a result, I'm not going to say that this turns on what the legal address of a child is at any point in time. Since the call was placed from the Tennyson, I'm using the Tennyson Center as an example,
Right.
Because obviously it has a favorable discussion about the ombudsman's disclosure, but if the call was placed from the Tennyson Center, that's going to be information that's in the report that the call was placed from the Tennyson Center. But critically there, just knowing that a call was placed from the Tennyson Center without additional information is not identifying. Now, we can come up with hypotheticals for how it is. But getting back to the statutory interpretation, the doctrine of constitutional avoidance would want any interpretation of that statute, whether it be of the term reports, the term name and address, or any other identifying information, to be limited solely to what is identifying information. We know that that's what the legislature wanted. We know that when there was no such distinction between identifying and non-identifying in Gillies, the General Assembly revised that statute. Now, I will concede that there are discussions in the legislative history about name and address, but all of those discussions use the words and more importantly, they're talking about what everyone thinks about when they're talking about a name and address. We're talking about my home address, or perhaps my work address, but not a residential childcare facility that is subject to 302, and there has to be some plausible way to ask for how well that facility is functioning. And one of those ways is to ask for aggregated data that does not disclose the identifying information of anyone at that particular facility. And so reading it under the doctrine of constitutional avoidance, reading it such that the final clause is not a separate category because it does say any other, so that word is critical, identifying information contained in the reports. It could have been just any other identifying information, period. It didn't. It said contained in the reports. And so that harkens back to the first category, the reports, and explains why the reports doesn't make the entire report identifying and therefore confidential. So you can't read name and address in complete isolation from the entire sentence.
Mr. Belkin? Yeah. Could 9 News and Colorado Sun issue a core request for the number of child abuse hotline calls made, let's say, to a town in Colorado or from a town in Colorado, population 500, population 200, population 100, or from a particular block? I'm just sort of trying to think about the...
Well, Your Honor, over what time period would be the question. But again, all of those things require exercise of the very same discretion by the custodian that the catch-all phrase requires the custodian to do.
And my question assumes also that the statute is ambiguous. So,
and my answer is that there will be a point where we will concede that it could be identifying, and at that point they would be justified in withholding that information.
And that just spins back to your answer to Justice Gabriel about sort of how this might look on the ground in terms of the department's responsibility to go through and look at the reports and make these determinations, I think, right?
Correct. And that's what the legislature wanted the custodian to do. We're not making this up whole cloth. Why include a catch-all phrase that requires them to think about whether or not the information that they could disclose should be disclosed as any other identifying information?
Can I just ask you as a practical matter, why would the address of the family or the address of the informant be included in the child abuse report?
Again, I'm not sure about the answer to that question, but I believe when the hotline takes the information, they take the name, they take the address from which the call is being placed, and then they funnel that up to Child Protective Services and the authorities.
But the statute says reports of child abuse or neglect and the name and address of any child, family, or informant, or any other identifying information. So that suggests that the report would include the address of the family?
It
They're
could.
not the facility.
It would certainly include the name of the individual, who's allegedly been abused at the Tennyson Center, let's say. It would include the name, the Tennyson Center, so that under their theory would include the address. And it could be that it's one of the workers who's there at that time who is doing their statutorily mandated reporting of child abuse. So all those information pieces could be in the report. We're not arguing about what could or couldn't be. We concede that the name of the abuse victim would be in the report, and we concede that if the call was placed from the Tennyson Center, that the Tennyson Center name would be there. Beyond that, we don't know what's in those reports, and frankly, my clients weren't interested in the details.
Right. No, I know. I'm just trying to make sense of this. Obviously, the brief spent a lot of ink on how to analyze the meaning of this statute, and when I look at this, it's perplexing. It's perplexing language here in terms of what the report would include and what is meant by these words.
Well, I think there are separate provisions that apply to what is required of a mandatory reporter in terms of the details that they're required to obtain and things like that, and that's clearly not at issue in this case. But interpreting the statute, while we concede that the dissents below, as well as the trial court's absolutist approach, is a reasonable reading of the statute, it leads to very unreasonable results. One, it creates the constitutional problem. But two, it logically would mean, for instance, that reports are entirely confidential by the same reading. There's no reason to go any further.
So if somebody was requesting a report, would you expect them to have the name and address and any identifying information redacted?
No, as I would read the statute, the reports themselves, the physical reports,
Be confidential.
are absolutely barred from. However, details within those reports, meaning it's sort of the inverse, Justice Samore, of what your question is. Right. Rather than having to produce the entire report redacted, they would only have to produce whatever part of the report is non-identifying, redacted for everything else that is responsive to the request.
That's what I meant. So why isn't it as simple in this case as to say the request for the number of complaints over a 3-year period at one particular facility is not a request that requires a disclosure of a name contained in a report, an address contained in a report, or identifying information contained in a report?
It is that simple. We're only here because the objection to disclosure was based on 307(1)(a). We never conceded that it was. In fact, we've always argued that the request here was not for the address. It was for a cardinal number. So if there are no further questions, I would just like to summarize that we believe the Court of Appeals interpretation is correct. At page 2 of their opinion, they define the analysis as first, that the statute should be interpreted to mean that name and address is only confidential when it is revealing or likely to reveal or could reveal. They use the words could reveal on page 2 of their opinion. And that is a perfectly plausible test. And that is absolutely appropriate to expect a custodian to do. So we ask this court affirm the Court of Appeals and find that because petitioners have never demonstrated how the disclosure of hundreds of calls from 3 particular facilities, despite opportunities to do so, they should disclose that information forthwith.
Mr. Belkin, so close to being done. I'm so sorry.
No.
I just want to clarify, though, when the notion of this being a request for a cardinal number, not for an address, you would concede, wouldn't you, that you could not, that a request from 9 News or Colorado Sun for the number of calls to the hotline from 123 Smith Road, right, isn't a request for a cardinal number? Or it is, but you would concede that's problematic?
I would, because that is an address with a singular individual associated with it.
A condo complex?
I'm sorry?
Same question, condo complex, same question, apartment complex.
Again, it's a residential address. I can conceive of, I grew up in New York City. There was a place there called Lefrak City that had 6,000 residents. Perhaps in that instance, I would argue that even the number of calls from that facility would not be identifying, but I'm not sure where the number is. In this instance, this court doesn't have to worry about that. And frankly, I'm pretty sure that the custodian of records for the Department of Human Services can discern where the dividing line is between entirely impossible, which is what our instance is, and potentially problematic, where they could either deny it or seek the assistance of a district court and present evidence on it.
So it turns on the answer to the cardinal number question.
It does, Your Honor. Thank you very much.